Okay, good morning, everyone. My name is Lena Wang. I am a partner at Gleho Bowles, practicing construction law in Toronto. I will be the moderator for this panel. First, I'm going to introduce the panelists, and then I will explain the format of this panel. We're going to do something a little bit different and ask everybody to take out their phones and participate using their phones. So first, we have Lorna. Lorna is a registered professional engineer with over 35 years of experience in claims consultancy, dispute resolution, and project advisory services across the construction industry. She has been appointed as an expert on more than 200 occasions as both a delay and quantum expert. To my left, we have Sahil, a partner at Gowling WLG. He is a recognized expert in construction and infrastructure law, trusted by industry leaders to navigate high-stakes disputes and complex projects. Known for his strategic insight and results-driven approach, he is a sought-after advisor and speaker shaping the future of construction and infrastructure law in Canada. Then we have Sam, who you should be seeing on the screen. She's joining us virtually. Sam is an associate general counsel at Microsoft. She's in that little box, but she'll become big soon. There you go. And she currently leads the regulatory enforcement litigation practice at Microsoft. In that capacity, she led the successful defense of Microsoft's $70 billion acquisition of Activision Blizzard against a multi-year challenge by the FTC. Prior to that, she led Microsoft's Office of Legal Compliance, and she's joining us this morning from Seattle. Okay. As part of this panel, we are going to be asking the audience questions and taking a poll. You will see, if you go to the next slide, you will see a QR code. That's one way to access the site. Another way to access the site is to go to the website, menti.com, and then enter the numerical code. On the subsequent slides, you'll see the questions, and you'll see the numerical code again in case you log out of the site for some reason, but the QR code will not be on the subsequent slides. We're going to hear from our panelists after each slide with the questions, and then we'll take a look at the results before moving on to the next slide. We have 7 questions to cover in less than an hour, and so we are going to ask you to kindly hold your questions until the end, and then you can revisit any of the topics that we've talked about. Okay, if you could go to the next slide, Seb. Okay, thank you. So the first question is, where are you on your journey in AI? Just gonna let people answer the questions for a little bit of time. Okay, I think we could maybe start with you, Sahil.
Yes, the results from the poll are very interesting. We were thinking that the results were going to show something else, but in any event, we really appreciate you being here, not only to listen to us, but also actively participate, because we also have a number of questions for you at the very end that we would like you to use as much information as you can potentially use, because you're going to have 200 character limit, and you can submit your response more than one time, and we are all going to see what the audience is going to tell us, and there's a surprise for you at the end as to what we're going to do with that information. Just making sure you stay at the corner of your seats. So thank you, Lena, and I'm so very glad to be here with both Lorna and joining Sam virtually. So the very first question is, where are you on your AI journey in construction arbitration? So from where I am and where our team is, I would say that we are in the targeted deployment phase. And what I mean by that is we're past some sort of experimentation. We have experimented a number of different platforms, but we have not yet fully scaled, adopted the use of AI. And where we are using AI in our large infrastructure construction disputes is where we bring tangible value. And what I mean by that is primarily it has been used and it's continuing to be used in document intensive disputes, some early case assessments, and some claim analytics that Lorna will speak to. And in particular, in the construction infrastructure arbitration, the volume and the complexity demand more than just the manual review. But at the same time, in my use of AI, it is not replacing legal judgment. And in my view, it is simply augmenting it. So while we are focused on using it to extract insights, it is not, at least my experience, automating decisions. What about you, Lorna?
So
Bring you closer.
within HKA, we have offices all over the world, and I can first start by saying that our use of AI varies considerably. We have files and experts who don't touch it, have not touched it, and we have others where it is being used extensively. At this point in time, it's being used heavily to review narrative-type documents, emails, reports, that kind of thing, keyword searching, putting together summaries, timelines, that sort of thing. Where we are still in the early stages and really looking to do more with AI is capturing data from forms, from imperfect forms that vary, to get data into a format that we can then use for analysis, either using traditional methods or using AI on those databases. We have a go slow approach. We don't want to simply allow experts to just jump on it without protocols in place, without a methodology in place, and without a control over what we do in it. So we still have a lot of work to do, but we're in it.
And Sam, I know the question will be modified for you, so not construction arbitration, but where are you on your AI journey? I suspect you'll be far, far ahead than the rest of us.
Well, let's just say
Dear.
this is certainly actively encouraged, if not actively monitored by the company. Yes, as you might, imagine, Microsoft is all in on the use of AI. I think, just to ground it just for a moment, I mean, Microsoft thinks of AI as a general purpose technology that will be applied across, all economic sectors, and certainly recognize that the road, to getting to full adoption is really going to depend and be anchored on, social acceptance that will come with trust there. So that's why, we're very serious about our responsible AI standards and are hoping to move toward, a regulatory environment that's cooperative and functional, because we think a lack of regulation over AI is not good for the public, or for, adoption and deploying AI in the way that we think it could be, a game changer in many ways in the world. But I do have experience across my two roles in the last, 5 to 7 years of beginning to adopt, first in the machine learning space, and then now, in full-on use in litigation. So happy to talk about, that journey and what our early uses are, and now what our current use cases are.
Okay, and maybe before we move on to the next audience question, if our panelists can tell us what's driven sort of the pace of adopting AI, whether it's a client demand or the firm culture, or some other factor.
Well, certainly, Lena, from my perspective, it certainly is client expectation. They want faster, sharper insights, and not AI for its own sake, but the value that you bring to the table and how it is being used to drive the results. And so that's from my perspective as it comes to client expectations. Lorna, what about you?
I'd have to say that risk is a factor, cost is a factor, and the learning curve. And I mentioned earlier that we're on a go slow pace. We expect it to pick up exponentially, but until we have a core team that have mastered the so-called right way to use the tools and have figured out what the right tools are, we really want to control the rate of deployment of AI within our organization.
Okay, so I see we've moved on to the second poll question, which is fine. We'll move there. That question being, what part of your workflow would you most love to hand off to AI? And so maybe we'll ask our panelists just to specifically to their area. So whether it's delay analysis or drafting or regulatory review, what tasks do you most wish AI could take over? And have you seen examples where AI is already improving that part of the workflow?
So Lena, I would concur with what the polls are suggesting us. We have 34 hits on sorting project records and emails, and irrespective of how we use AI and where we can implement AI, that is certainly an area where I personally am very interested in as to how it can be used. Because if I could hand off one thing, or not only hand off, but also use it much more efficiently, is the forensic trolling that is required of the project records. And, memories fade over time, people move jobs over time, people not only move within the organization, but people also leave the companies. So the endless hunt of the key facts, which is sometimes buried in years of correspondence and meeting minutes and RFIs and schedules. And yes, it is the grunt work of construction disputes, which primarily speaking isn't law. Yes, you're looking for key facts, but it's the sifting through the noise to find, 3 to 5 key emails, or sometimes what is the primary baseline schedule. I think Lorna would probably speak to that. And like our polls results have suggested, AI should be doing that, and perhaps getting the matters ready for a hearing on a much compressed schedule if possible. And also, it's not that we are just all of a sudden going to start using it. We have been using it for quite some time. We are doing targeted keyword searches. But in my ideal world, you will take it a step further by using a much more contextualized, cross-referenced extraction, which could potentially flag contradictions in evidence for you. It could, and I'm sure when you're working with experts, highlight scopes that are drifted over time, and identify silent delays before anyone puts a name to that particular delay event. So that's what I would say, how it could be more contextualized to how we can really help with the project records. Lorna is smiling because I'm sure she's got something up her sleeve.
So I do have a different perspective. I'm an engineer. I hate stuff that's written down. Who actually writes things down accurately, right? Whereas on our construction projects, we have cameras. We're filming everything 24/7. We have our production equipment, our big loaders, they're all equipped to capture data. We know every shovelful of dirt that was picked up by every shovel, how much it weighed, when it was lifted, where it went, et cetera, et cetera. The amount of data that's available is phenomenal. So I want an AI tool that I can tell, go through the years of footage of filming, because I've got gazillions of cameras, and find me clips that show the bolted connections on structural steel where you see evidence of rust or mistorquing or something like that in this sector in this time period. And do it for me in the next 3 minutes. I want to be able to leverage the data that we're already capturing. And we can't do that without AI.
Sam?
Yes, I, relate to that. One of the things that we learned in the compliance space, for instance, that is a place where there is a natural, kind of body of data. And we wanted to harness actionable insights from all of the data that we had across so many different sources. Like in the compliance space, for instance, we would have, baseline information about the number of business conduct compliance complaints. We would have information about the rate of deals. And our first, deployment in trying to gain really insights that we could share and learn from and improve our program were the efforts that we undertook when we were under great scrutiny by the Department of Justice and the Securities and Exchange Commission over, deals that we were doing in the public sector in countries all around the world. And what we were able to gain from an analysis that we were doing, hard on the ground review of those, facts that Sahil was lamenting are so hard to find. But eventually we had amassed a list of, just a straightforward, plain list of what are the types of red flags that may point to anomalies or higher risk deals that really should generate a pre-deal review before they were approved, because it's too late after the deals have been approved and the money has gone out the door. So we identified the risk, the red flags, and we fed them into an early sort of algorithm that then was trained to review all of the deals coming through our program for which red flags were present, and it would apply a risk score. And those that scored above a certain risk were then reviewed, manually. That was what we shared and presented to the Department of Justice. They definitely expect, that tech companies are going to be deploying that kind of technology to solve, common and recurring problems. And though it was a clunky sort of, heuristic model in the beginning, we were able to feed it and evolve it over time and apply our, emerging, then pretty nascent AI technology to make that more, data-driven and much, much, much faster. And so that was one of our early records. We then, moved on to deploy it in analyzing bids, for instance. So in the public bid environment that you all would be familiar with, we were able to kind of set up a statistical analysis to look at data across bids that were being awarded to try to identify any gaps in what would be a healthy level of competition across the bidding, for example. Like, were there any countries where anomalous bid award practices were identifiable, and then we could examine, our own role in that. Now we moved on to where, for instance, we have a culture tool that analyzes just massive amounts of data coming in from all over the company in terms of, poll results, workplace polls, data about varying corruption risk in various countries, and put that into a culture score that every one of our managers across the company can use. And now we've had to think about how to use the data-rich and proactive environment and culture that it takes hold in a compliance space into how that might work in litigation, which has historically been more reactive, more dependent on things in the past rather than predicting outcomes in the future. And so I'll talk next. I don't want to take too much time on this question, but I'll talk next about how it is, how we're applying it right now in our litigation department and how we expect that will evolve in the future.
Okay, maybe we'll move on to the third question, and then we'll come back to you on that,
Okay.
because I do really want to hear
Okay.
about that. So the next slide, please. So the third question is, what's the biggest speed bump on your road to using AI? Or suppose there are no speed bumps and no one answers the question. Okay. So maybe, Sahil, you can start by telling us what challenges you see to adopting AI.
It's very similar, Lena, to the results that we're seeing on our screen, based on the poll results. I believe the biggest constraint isn't really one in technicality, but it is certainly one in trust, and the results show us just that. And on a more practical level, from my perspective, there are other two challenges which dominate that same idea behind trust, and that being both confidentiality and privacy concerns, because the disputes and the subject matter pertaining to any dispute are loaded with sensitive commercial data, in particular pricing, strategy, sometimes proprietary design, and no clients want that to be fed into a black box tool, especially if it lives in a cloud that they do not control. And similarly to that, there's also a factor in terms of integration. And what I mean by integration is that the AI tools aren't yet being the key word, fully plugged into the workflows. In other words, they demand, as Lorna mentioned, technical onboarding, training, and validation. And I believe we still have significant amount of work to be fully set up to handle, including for external counsel who are working on mandates of this nature.
So, from the perspective of a service provider, where our business model is based on selling time, when we go to our leaders and say, hey, we've got this great tool, and if we use it, our revenue is going to plummet. And our leaders look at us and shake their heads. Of course, I'm exaggerating a little bit, but the impact on the business model is something that needs to be thought out, and we're not there yet. Technologically, certainly those issues are our issues as well. We think that working with these different vendors, the same way we're all now comfortable using relativity, we can get over it, we can deal with it, and it'll work. But it takes more than that. We have to figure out how to properly adapt our business model so that the use of AI is of benefit to our clients and makes sense as a private company that's in the business of making money. And there's work to be done before we have that all figured out.
Yeah, I've certainly had, speaking for myself, excuse me, even just my note-taking app, when I join calls, other parties have said, I don't know where this information is being stored, and like kicked my circle back off. So I do agree with you on the lack of trust and the privacy confidentiality concerns. Sam, maybe we could go back to you and you could tell us about how Microsoft has adapted what it's learned from the compliance using AI to litigation, and whether you've had to address any of these concerns here.
Yeah, I mean, for sure. We are addressing, concerns on our side, on the side of our outside counsel firms. We do really recognize that, this is a really significant transition in the practice at large. We're all, lawyers and professionals and experts. We understand, how complex litigation can be, and we're really clear with our outside counsel and within our own team that AI will never be a substitute for legal judgment. We don't think of it that way at all. I mean, rather than think of, AI as replacing the work of lawyers, we think of, AI or lawyers using AI will replace lawyers who don't use AI is more of the catchphrase that we've used. But having said that, there is no, given of course our, particular and unique kind of interest in, perpetuating and getting widespread adoption of our tools, we have had the direction to move really aggressively in the litigation space. So for instance, right at the outset and, addressing the issue about, how we have traditionally thought of time in connection with litigation and use of outside counsel. Right now, in our new template for requests for production, if we are bidding out a large matter to law firms, we have inserted and added a new section where we ask the law firms to tell us, how they intend to use AI to make their handling of our matter and the project more efficient. So we want to put some of the onus on the law firms to pick up and adopt. We're also using a kind of a co-use model where, we have developed a tool that we're using in e-discovery. It does many of the things that, Sahil talked about. It, coordinates, it does all of our keyword searching. It summarizes massive amounts of documents. It can organize, chronologies. It can organize matters by topic. That makes the process of, organizing discovery and trying to assess your case early on much, much, much more efficient. And we do hope, I mean, just jumping straight to the question about the billable hour, we do see that it will be a disruptor, but we've long been hoping for disruption in that space, and that probably comes as a surprise to no one. Our view of it is that we have long wanted to move to kind of value assessment of a matter, and that we would like to adopt a project fee that is based on the total value of the matter. And that, our hope is that that will create mutual incentives to, bill a matter not based, on the traditional hourly increment, but instead on, a mutually agreed upon assessment of what is the value of the matter. We call that, matter value estimating. And that is what we see in the future. That's what we're driving toward. And, the hope is that that creates better work for counsel and for experts and legal professionals, that it takes away a lot of the drudgery of the work and makes, kind of the analysis and the advising and the creativity that's always been a part of the practice of law more, more efficient. One other thing that we've done, is across, that's adjacent to the use in e-discovery, is to develop kind of case-specific tool sets, AI databases. So for instance, Lena mentioned in her introduction the work that we did to defend the $70 billion acquisition of Activision that we announced in January of 2022. That matter only came to a close last month with the decision from the Ninth Circuit and then the withdrawal of the FTC docket of the final administrative proceeding. So that was a full-on 3-year effort. It involved defending the case in 37 different regulatory inquiries in 37 different countries. And then, of course, the litigation, not just by the FTC, but by a group of, private gamers in a matter that also sought to get an injunction to stop the acquisition. The amount of data that we had collected was so massive. It stretches, my ability even to, define the data. But what we did see was that it provided a fantastic opportunity to experiment and to learn. So we uploaded all of the data that we provided to 37 regulators and to the United States Federal Trade Commission into one set of data, and we used it to practice on and to iterate and to get better at, saying, find me all of the data about the share of the market that Xbox has had over Sony's PlayStation in France since 2010. And, now analyze it against Nintendo's share in the United States, or even down to the level of the game. What has been what's the arc of the percentage of growth of players playing Call of Duty, for example. And we use that data set to examine how good the AI tools were. And then we would sort of compare them with what we knew, what our experts had, written in their reports, testified to in trial. And we were able to compare and see where the flaws were and what might be causing the flaws. And then to feed that information back, to our, in-house sort of AI researchers and developers, gave us a really great real-time opportunity to test and pilot. And you definitely need those. We are wary, as we should be, as every lawyer should be, as recent examples have shown, that, AI is a flawed technology. It will not deliver accurate results anywhere near 100% of the time. So again, there is no substitute for applying and layering on top our own judgment as, lawyers and experts and legal professionals. But we do see where the puck is going, and we all will need to change and adapt along with it.
Any comments on this before we move on to the next question?
No, I think in the interest of time, we should move to the next question.
Okay, so maybe we'll move on to the next question and just bring us back to arbitration and perhaps construction arbitration, where we're probably catching up, or at least trying to catch up to where Sam is at. And the question is, how close are we to AI being expected in arbitration or construction arbitration? Overwhelming.
Yes, very much so. It's already happening in some circles, or within 2 to 3 years. So, Lena, I'm going to take this question from a different perspective in terms of how the tribunals and the arbitrators are approaching it based on my experience. And in my view, and where AI is being used right now on the mandates that I work on, it appears that the tribunals are generally open to be assisted by AI, provided it is used both transparently and responsibly. And what I have also observed is that arbitrators primarily care, as they should, about the quality of the output and not the tool that is used to produce it. So what has occurred, or has occurred in my experience, is this discussion is taking place during the very first procedural order meeting, and there is an open discussion among parties with the tribunal as to will either party be using AI assisted tools for doc review, for analysis, for submissions, and how will those tools be disclosed or explained to ensure procedural fairness, and what safeguards are in place to preserve privilege, confidentiality, etc. And on a large infrastructure project, that is exactly what, in my experience, we've done it to take to a hearing in 1 year from when the first procedural meeting took place. And in having gone through this exercise and having had the open dialogue with the council and the parties involved generally, it is my view in that particular case that the tribunal has de-risked any misunderstanding right up front, to an extent possible, avoid any objection about the process integrity, and to ensure that we can move forward with the adoption with a clear understanding in mind as to how it is going to be used.
Lorna, from your perspective?
So I have a different take on this. It's one thing for the dispute resolution community, be it the arbitrators, be it counsel, be it experts, decide if and how to use AI in the resolution of the dispute. But you don't have a choice with regards to how the parties may have used AI during the actual execution of the project. It's done, or usually it's done. And AI, we know, is being used, is being adopted in industry, and specifically on construction projects, far faster than it's being adopted within the dispute resolution community. And we're construction, I'm a delay expert. My personal view is that critical path scheduling is archaic, inefficient, and AI is going to turn it on its head. And we're going to see more and more projects where the decision-making about how the work proceeds is driven by, or certainly assisted by, AI. We're going to see AI used both administratively in taking minutes of meetings and things of that nature, through workflow and how changes are managed, a whole host of things. So counsel and arbitrators and experts not only have to deal with, well, do we want to use AI, but also how are we going to deal with information that's coming at us that was generated or processed or resulted from the use of AI during the execution of the project. I'll stop there.
Okay, maybe we'll move on to question 5, and I'm sort of eager to get to the, you know, the surprise, which is questions 6 and 7, I think. So question 5 is rate your current AI usage in dispute resolution workflows. And I believe we would see, so once it starts popping up, we're going to see a graph, a chart.
It'd be fun to do this 2 years from now and see how that number changes.
It would be,
course.
yeah.
6 months from now.
Kind of lower than I expected, but
Yeah.
I don't know about you guys. Any comments before we move on to 6? No? Okay. If we can move to question 6. So this is the one where you can input your own answers, and you can put as many answers as you like. There's a word limit, but I don't think anyone's going to exceed that. It's like 100 words. And can I tell them what the surprise is going to be?
Maybe after the response.
Oh, okay, sorry, yeah. You will be shocked. Definitely seeing a couple themes here emerge. Okay, wonder if anyone is still inputting. Maybe we can do the press the magic button thing, Sep. The surprise is we're going to use AI to summarize the results and see how it does.
So certainly disclosure
Yeah.
got the top spot.
What you're seeing on the screen now is the result of the use of an AI tool now, real time. It has taken all the responses we received from this audience and grouped them, summarized them and grouped them.
Where's the none required?
Yeah, right? That's a good point. There were at least 4 or 5 of those.
There were several none required. One at least I know of.
Can you
Seb,
scroll-
if you scroll down, do you see that category?
Sahil rocks. I don't think that was an answer to the question that's asked.
Sahil rocks.
I'm
Holy
not sure who
smokes.
said that. Yeah.
Interesting. No. So are we seeing maybe AI not accurately summarizing our responses, Lorna?
Ponies and unicorns, good heavens.
Interesting, huh? So we do have one more question left, but I wonder if now is a good time to sort of open it up to the audience. If you have questions or comments, if you want to revisit something we talked about earlier, we can go through the slides again. I think the poll results will show. From if we. One more question. Do you want to do the question first?
Yeah, let's do that.
Okay,
Okay,
let's
let's do
do
the
question
last one.
7 then.
Seb, we'll do the next question, please.
Okay, thank you. So this question is, what words come to mind when thinking about AI in dispute resolution? And you can input your own answers.
I think I saw one response as lunch.
Is the idea, Lorna, efficiency is center and large because many people have entered that?
Yes,
Okay,
the size of the word is an indicator of the number of
the
people
number of
that have.
times, okay.
Interesting.
A minority report is up there.
Yes. So certainly efficiency, speed, and confidence. And pardon
My-
me?
Well, you've got risk and risky up there. You combine those two, and they're
Yeah.
pretty.
Scary, bad. Well, there's exciting as well. I think somebody used magic.
Magic.
Okay.
Okay, should we, do you want to make any comments on this, or should we open it up to?
Sam, what do you think? Anything that stands out to you?
Well, just a minute on the disclosure question. I mean, in the context of litigation, when, counsel are filing briefs, we all know that we have an ethical responsibility, to ensure the accuracy and to, vet any, quality that is always going to fall on to the attorney. So I think there's a pretty decent argument to be made that it wouldn't be necessary for, counsel to disclose, for example, that, they had used AI tools. I do think it's a different question, though, for judges and arbitrators. I think it raises more of a specter of, transparency and accountability and, kind of a due process for the participants to understand if, judgments or decisions or findings of fact or law or recommended settlement amounts, for example, are based or generated in part by AI. So on the disclosure front, I think that's something that in the arbitration space, tribunals should be thinking about. And I'd think about that differently. So that's my comment about disclosure. Happy to talk about other aspects. I mean, I know in our the construction arbitration space, given our large data center projects, it is an enormous amount of, potential issues and claims and disputes to manage. Overall, the business does a remarkable job at, building good relationships with their suppliers and their builders and their lessors. And the sellers, that they're purchasing real property from. And, we have an interest in maintaining those healthy, relationships across that ecosystem. So I would say that we've got a, fairly remarkable record on reducing construction litigation. But, certainly to Lena's point about as more of the underlying decisions that animate, the construction and build industry, that will probably enter into disputes in the future. Like if this, what does it mean to say that a schedule was dictated, by AI rather than by incidents on the ground and communication between individuals. So that's something I think we'll need to, prepare for and in the space. One more just really quick comment about the legal tools that are proliferating. So outside of our own kind of homespun, bespoke uses that lawyers or experts or, technology companies come up with, you all know that the amount of third-party litigation support services using AI are just, proliferating. Our old standard, kind of LexisNexis databases of, millions and millions of cases are, being organized and in theory are available to generate, jurisdiction specific memos. And that in the construction space might be very valuable. What is the law on estoppel in, any given or force majeure in any given jurisdiction? There is a specific Gen AI tool that is purported to be used for arbitration. It's called JUICE, J-U-S AI Assistant. So we're going to see the tools and we're going to see them enter into our arbitration space. But to me, the word I put into the chat was accountability, because I think we all need to be prepared and that it should be part of our standard kind of guardrail to be accountable for what we used, how we used it, how it impacted, results, how it impacted, the any individuals that may have been affected. And so I think it's incumbent on all of the practitioners and users of these models, whether it'll be lawyers, experts, construction managers, or ultimately arbitrators. Each of those individuals and entities needs to be able to explain, do after action reviews, and to hold themselves accountable for the accurate, fair, and safe use of the tool.
Yeah, I think that's a great point and a good place for us to go to the audience for some comments and questions on anything we've talked about today. You guys answered every single question they had.
Or they're just hungry.
Or they're just hungry.
There we go.
Just because this came up at a webinar I moderated recently, so there's more and more concern about the inadvertent or deliberate use of AI to change the meaning of evidence, whether that's translation or deepfake images or so on. And I've heard talk that there is a sort of an arms race developing in the legal context as in other places, as AI tools being spun up to detect whether documents, images, so on, are themselves created with the use of AI tools. Do you have any insight you can provide on which of those are effective, if any, what direction the technology is evolving in?
Certainly, I think it's more about the process development than the output itself. I believe as part of the parties' document exchange protocol, as the courts are doing, there's ought to be something along the lines of the idea by a counsel involved that requires signing a certificate that this is the data. And inadvertently sometimes, I think as counsel, you're also depending on your clients who are giving you the data. You're not double checking that the data is actually from the underlying project as the project was being executed. So it certainly is going to be very crucial. But Lorna, what are your thoughts in terms of if the data didn't exist really, but is now being used by the parties?
Well,
How do you do that job?
you're opening up a whole new area of expertise that will be required. Yet more experts in that room. Yep.
Sam, what are your thoughts?
Yeah, I actually think that ties really neatly back to the accountability point. I mean, producing kind of candid assessments of the use and evaluating that and having good data, governance is going to be especially important. The meta comment about, using AI to detect AI, I know I am familiar with that, use that's being, rolled out in that space. You're right. It's going to require just, extra vigilance and transparency. That's, the twin sister of accountability has got to be transparency. And I think that the legal profession is going to need to push for that and ask the right questions and, kind of demand that level of, you mentioned certification. I think that's actually not a bad idea. I would, be in favor of pursuing some sort of, guarantee or transparency along those lines so that everybody knew as best they can, what they're looking at and where it came from.
Excuse me. Anyone else? Oh, Donnie has a question.
Hi. Just a quick question about explaining AI to tribunals. I mean, we know, for example, in the context of lie detector tests, that it's not that there is no science to them, but quite often, for the most part, that sort of material is not used in judicial or arbitral processes because the issues with it, the flaws with it, are not well understood and not readily explained. And so by analogy, when one thinks about the use of AI in arbitral processes, have you seen examples of experts who are able to explain AI well enough so that tribunals can get to grips with it?
Does anybody want to take that one?
Well, the only comment I would make, I guess it's more specific to juries, perhaps, than to a judge or an arbitrator. We know that there is great resistance generally to explanations about sophisticated technology. In our experience, juries and to a maybe slightly lesser extent, judges or arbitrators, they prefer narrative to technical specifications, right? They want to understand the story, and the data has always, maybe much to the chagrin of very analytically minded, practitioners, it just has been less important. So, I think what we need to not lose sight of as we work to protect and to verify and certify the accuracy of data is that we can't lose track of the story that the data is meant to tell. And I think that will always, I like to think human nature will endure and remain roughly the same through this, nascent technology revolution. But I think we also need to think about the stories that we tell, and whether, our data, what the data shows will probably always be slightly less significant, but there will be a huge learning curve in trying to explain AI to not just judges and arbitrators, but to juries. And we need to be prepared for that and think about the simplest and clearest ways. And I would base them in, narrative rather than tech.
I think we have 3 more minutes. Does anybody have any other comments? We have many arbitrators in this room. I'm sure some of you have used AI. Okay.
Thank you, Lena.
Thanks, everyone.